versus Cade Kuinga, file 25-43904-FY, set for sentencing. I do see Mr. Kuinga is present. Mr. Truce, I believe this is your matter as well.
It is, Your Honor. Thank you. Richard Truce, appearing on behalf of Mr. Kuinga.
I believe this was set for sentencing today. We had a plea to a moving violation causing a serious impairment of a bodily function back in November. And we adjourned it for sentencing. I think it got bumped once from December to now. I have received a restitution request.
The court session begins with confirmation that this is a sentencing hearing. The issue of guilt has already been resolved. The defendant has pleaded. Now the only question is the consequence. The charge is moving violation causing serious impairment, which is far more than a simple traffic ticket. When serious injury results, this becomes a felony-level matter. An emotional element is introduced as well. The defendant has a newborn baby at home. While that may influence sympathy, the court must separate emotion from legal responsibility. The tension is immediate. Will this result in jail time, probation, or both?
Office for $300. Mr. Fortier, is that the accurate amount of restitution being requested?
Yes, Your Honor.
Mr. Kuinga, I'm going to hear from both of the attorneys as to what they think should be done for sentencing. And then after you've had a chance to listen to them, I'm going to give you an opportunity to say anything else that you wish prior to my decision about what to do in this particular case. Mr. Fortier, go ahead.
So, Judge, I understand Mr. Kuyenga's young, but this was not his first driving related issue. I know one of the main things that sticks out was the number of times that he had been involved in traffic crashes or accidents, pulled over for whatever reason. March 16th, 2025, there was a traffic crash. April 5th, 2023, was another traffic crash. He failed to display a valid license in October of 2021. Speeding citation on January 10th, 2023. Another speeding ticket in October of 2021. No insurance ticket in October of 2021. Failing to stop and identify after a personal injury accident in 2021. Another no proof of insurance in 2021. Another traffic crash in 2020. So it's a situation where an individual, he's got an atrocious driving record. And, on the day in question, it was very slushy out. He's speeding around an area known for its curves. So this was in the area of Martin Lake Road and M32. Slush grabbed his car, pulled him over, hit another vehicle head on. I'm not in any way suggesting that Mr. Kuyenga had the intention to do what to crash.
The prosecutor presents the defendant's driving history, and it paints a troubling picture. This was not an isolated incident. There was a crash in 2020, another in 2021, speeding violations, driving without insurance, failure to identify himself after an injury accident, yet another crash in 2023, and again in 2025. In sentencing, judges do not look at a single bad day. They examine behavioral patterns. When incidents repeat over years, negligence begins to resemble recklessness. The prosecution strategy is clear. This outcome was not unpredictable. It was foreseeable.
His driving is just beyond it's just abhorrent, really, at this point. And I want to highlight some of the injuries that the two victims sustained, and thank God neither of them were killed, and thank God that Mr. Kuyenga wasn't killed. Miss Carroll, she had a C2 vertebrae fracture, a fourth right rib fracture. Her 9th, 10th, and 11th left ribs were fractured. She had a fractured lumbar spine. Her sacrum was fractured. She had a fractured right fibula. multiple broken bones in her hand and wrists for both hands, both right and left. She had a fractured ulnar bone on her left side, and she had to have a surgically placed chest tube in her right lung. Larry, who was driving the other vehicle, he fractured his C2, C3, C4, C5, and C6 vertebrae. He had a fractured sternum. His right first rib was fractured, large bruises on his buttocks and hips, and he had a torn quadriceps muscle.
The court then turns to the victim's injuries. AC2 vertebral fracture, a serious injury to the upper spine, multiple broken ribs, a collapsed lung requiring a chest tube, ongoing medical treatment and recovery. These are not minor injuries. They represent significant trauma with lasting consequences. Legally, serious impairment of a bodily function is a defined threshold. Based on the injuries described, that threshold appears clearly met. This is where the prosecution justifies requesting jail time. The harm was substantial and life-altering.
Both of these individuals are still undergoing essentially treatment and care and recovery for this accident. Something that probably could have been avoided if Mr. Kuyanga just slowed the heck down. I know there was an original sentencing date back in December of 2025, where Ms. Brooker was covering that day, and she did allocute for jail. I think jail in this situation, again, recognizing, no, he didn't have the intent to injure Larry and Carol, the victims in this matter, but he did. And I think, his record supports the court putting him in jail. And I think Your Honor had alluded to the fact that we were setting this off because Mr. Kuyanga was having a newborn child and we wanted to give him some time to kind of get things set up. And there was basically the court alluded to 30 to 45 days in jail and taking away his ability to drive for any pendency of any time of probation. So I would ask the court to order probation, that $300 restitution. I think a driving class at minimum, if he's wanting to get an opportunity to drive again, the court should restrict his ability to drive. I don't know necessarily what any sort of Secretary of State consequences will come from this. But the court certainly, I think, should prohibit him from driving an automobile while he's on probation. And I think the 30 to 45 days in jail would be appropriate.
All right, Mr. Trush, allocution.
Thank you, Your Honor. This is a circumstance where I think the prosecutor hits some of the things right on the head. I don't think that this is a circumstance where Mr. Kuyanga is, setting out to do harm. I think that this is a circumstance of negligence or neglect. It's a circumstance where again he's acting in what I would term a reckless manner more than an intentional manner in terms of the harms that he caused. I think that's very clear. The prosecutor outlined some of his history. Frankly, I think most of that in isolation probably wouldn't really move the needle. But it's not in isolation, right? It's not. Many of those things are insurance tickets and things like that he listed, but there's accidents. I think there's no doubt that Mr. Kuyanga needs to change the way that he operates a vehicle, or frankly, he's going to become, uninsurable. If he's not already at that point. My recollection was that the court had moved the sentencing date out because, as the prosecutor had indicated, the court had clearly expressed an intention to limit or remove his ability to drive. And I think it is accurate that the court had identified, or Mr. Kuyanga had identified, that he was expecting to have a child. And I think the court recognized that limiting his ability to drive with that circumstance might be setting him up for failure. Frankly, I think that the court taking action against his license is appropriate. candidly, I didn't look at the statute today, but I'd be shocked if the offense that he pled to didn't result in him losing his driving privileges anyway. Again, I didn't look at the statute ahead of today's hearing specifically for that, but I'd be shocked if it didn't. Um, in terms of what a sentence should look like, I would suggest to the court, bearing in mind that I think either the court or Secretary of State or both are going to be taking action on Mr. Kuyenga's license. I don't know that probation is
Sorry,
really
I'm
likely to
doing a
be.
court. The sun's shiny over here, so I'm.
We mute Mr. Montgomery, please.
I,
Thank you.
That is
Go ahead,
done.
Mr.
I don't think that probation is likely to be tenable. If he has no ability to drive, his ability to report, his ability to test and do things, I think are largely going to probably set him up to fail, and set him up to be violated and be here facing potentially more jail. I would suggest to the court, and I've discussed this with Mr. Kuyenga, I would suggest to the court a jail sentence up front, I think is appropriate, given that he's going to have his license, again, his ability to drive taken away in one form or another after today. I would suggest to the court that imposing the upfront jail sentence but not imposing probation may be a better way to address this. Again, I think all the other things the prosecutor has suggested in terms of limiting his driving privileges and taking a driver's improvement course could be ordered. But ultimately, I think that probation likely puts him in a position to essentially violate by things that are, I'd say, largely out of his control. Thank you.
Mr. Kuyenga, you also have the right to address me. Is there anything that you want to let me know at this time?
No, Your Honor, I believe they pretty much covered it all. I know I'm responsible for my actions, even if it was something that was unintentional, and I'm ready to make this right and move on. With a newborn son and my girlfriend not working, I'm just trying to get this behind us. Really hope it doesn't break us or lose our job. I'm really just trying to stay on my feet, but at the same time, I am willing and ready to accept responsibility for my actions, Your Honor.
Mr. Kuyenga, I'm pleased to hear you say that. It is sometimes difficult to come to that position when you are a young man, young person in general. And I guess I'm going to ask you for a moment to try to put yourself in the opposite side of this case. The family.
The judge gives the defendant an opportunity to speak directly to the court. This is known as allocution. It is often one of the most important moments in sentencing. The defendant apologizes and accepts responsibility. Notably, he does not blame the weather, road conditions, or other drivers. That is a strategic and mature approach. However, remorse carries different weight when there is a repeated history of similar conduct. Words matter, but history matters too. The judge listens not just to what is said, but to what the record shows.
The people that are now going through the rehabilitation for the physical injuries that they received as a result of your actions. What do you think that they would want me to do in this particular case?
If the roles were reversed, I would definitely, seek justice. I would want everything that I had to pay for out of my pocket, covered by the opposite party. It's really hard to say what exactly I would want when I am not in that position, and I am not, without any disrespect, I am not an older or elderly person. It's really hard to say, Your Honor.
And I appreciate that. It's on purpose that I tried to put you there, even if you can't come up with a good statement of what should be done. I want your mind to go there. I think you would understand it even better. And I'm not saying I want this to occur, but you would understand it better if someone had hit you and your family coming home from the hospital.
Yes, sir, I would.
And that is what happened here. You took some other family out of their normal set of circumstances, their everyday life, and you caused them in reality and literally a world of hurt,
Yeah,
and
sure.
they will not recover from it, maybe ever. They will still have the scars. They will still have the pain. They will still have those memories of them doing their normal lives and having that interrupted simply because you were going too fast for conditions or were careless in some other manner, whatever it was. And so I simply want this sentence to help you to understand that problem. There isn't any amount of jail time or any amount of fine or any amount of anything else that I can do to make up for the pain that you've caused.
Yes, sir. I understand that.
So all I can do is hope that you gain some wisdom from this and never have it happen again. Because I agree with the prosecutor. Your history of crashes, you're a ticking time bomb, dude, when you're in a car. You've got a crash in 2020, 2021, 2023, and now 2025. And it finally caught up with you. You really hurt somebody this time. And so as a part of that, I'm not going to wait for the Secretary of State to do whatever the Secretary of State's going to do. You are not going to drive while you're on probation.
Yes,
Period.
sir.
That's going to put a huge crimp in your style. That's going to make life difficult for you for a long period of time. And part of that's on purpose. I want it to be a penalty for you. I want you to, every time that you can't get in your car and go where you want to go, I want you to think about this family that you hurt. That's part of the growing up lesson.
Yes, Your Honor.
On the other hand, this is not you trying to do this. I get that.
At this stage, the judge makes a striking comment, referring to the defendant as a ticking time bomb. This reflects not just frustration, but risk assessment. Sentencing is not only about punishing past conduct. It is about preventing future harm. The judge restricts the defendant's driving privileges during probation. The reasoning is preventative. If the driving behavior does not change, the next accident could be worse. This approach emphasizes long-term correction over immediate punishment.
So I am not going to just throw the book at you because it feels good for me to do that. That's not where I'm coming from. But I do have to keep in mind the victims in this case and the damage that's been done to them. And there has to be some proportionate response. And so I'm hopeful that this will do that. I heard your attorney say, hey, let's not do a long period or any probation. Let's do a short period of jail up front. And I get that. But I think the best way to reach you as a young man is to stretch out the length of time that you have to think about this. I know that you want to put it behind you, and that's a normal reaction. I don't think there's anything wrong with that. But as a judge, I want you to think about this for the foreseeable future. There will come a time where it will fade into the background. Life will continue to happen and you'll move on. But I don't want that to be imminent. I don't want that to be the first thing that you think about. I want you to understand this and the impact that you've had for the long term. So I'm going to put you on probation for 9 months. There's a $270 crime probation oversight fee for that. There's a crime victim fee of $75, restitution in the amount of $300 to the victims. There's a justice assessment of $50.
Judge, real quick, I don't want to interrupt, but I did want to. I just caught this. So the owner of the vehicle that he was driving, she had a no insurance ticket that was issued as a result. Part of her sentence back on January 22nd, the court ordered fines and costs and then also ordered the $300 restitution, but joint and several. So if we could just do joint and several on this one as well.
No
You have the
objection.
name of that? You have the name of
Rena,
that?
or Renee, maybe Rennea. Last name Krussell.
All right. Thank you very much. I do appreciate that. That Mr. Kuyinga will have the effect of reducing the amount that you would have to pay if she pays her proportionate share of that. On the other hand, if she doesn't pay, you would be responsible for the whole $300, and you could then sue her But the idea is that both of you would pay that $300 amount. Does that make sense to you?
Yes, Your Honor. She's currently not working, so I will be paying her portion as well as mine.
All right. I just wanted you to be aware. There are court costs of $300, a fine of $150, and a local charge of $15. Let me add all of that up for you. A total of $1,160. You can pay that over the course of probation. You may perform community service in lieu of some of those fines and costs at the discretion of the probation office. You must enroll in and successfully complete a driver's improvement program. The probation office will assist you in trying to find an appropriate driver's improvement program. Are you currently working, sir?
Yes, Your Honor.
What's your schedule?
I work second shift, so it'll be from 3 p.m. to 11:22 p.m.
You have vacation days coming?
I believe my 1 year's coming up in about 2 months, but as of right now, I have no PTO or ESTA days.
Is that where you reside in Petoskey as well?
No, sir. I reside in Boyne City.
I'm going to impose 20 days jail. When would you like to begin to serve that?
That would be something I would have to talk to my girlfriend about to know an exact date.
Well, unfortunately, I'm going to set a date today.
Okay.
So here are your options. You can start it at a date certain, relatively close to now. You mentioned the reason I asked about your time off. If you have employment, I don't necessarily want you to lose your job. So if you need to wait for a specific date when you have time off, such as 2 months from now, I'd be willing to allow you to do that. But once you go in, you're going to stay in. There isn't any going in and bouncing out, and going in and bouncing out kind of thing. So if you want to give me a date 2 months from now when you'd be available to have time off, it may not cover the whole 20 days, but it'll cover a substantial portion of it. That'll give you time to make up whatever you need to do with your employer as far as telling them, hey, I'm going to be gone for this amount of time. If you want to do that, I'll be happy to allow you to do that, but you're going to do 20 days in jail in a chunk. When would you like to do it?
Honestly, the sooner we can get it over with, the better. Because I'm not sure when my PTO hours will reset. I'm not exact sure of my start date.
All right. Today is the 19th. Tomorrow is the 20th. You'll report to jail 6 p.m. Otsego County Jail on February the 20th.
The final sentence is announced. 20 days in jail, 9 months of probation, driving restrictions, over $1,000 in fines and fees. Restitution is ordered on a joint and several bases, meaning if the co-owner does not pay, the defendant may be responsible for full amount. This is not the maximum possible punishment, but it is structured accountability. Jail serves as immediate consequence. Probation serves as oversight and reflection. Financial penalties reinforce responsibility. This case ultimately sits at the intersection of accident and accountability, where repeated driving behavior transforms a tragic crash into criminal responsibility.
You also may not drive during probation.
Yes, Your Honor.
All right, Mr. Kuyenga, do you have any questions as to the sentence for today?
No, Your Honor.
Mr. Trush?
No, Your Honor, thank you.
Mr. Fortier, anything else?